Families don't create long-term trusts casually. Multi-generational trust planning is usually done with the best intentions to protect wealth, reduce taxes, and preserve family harmony long after the original trust creator is gone. Yet in California, even well-intended trust plans fail far more often than families expect. I'm Michael Hackard. For decades, working with California families in trust planning, administration, and litigation, I've seen a clear pattern. Most trust failures are not caused by bad intentions or bad law. They are caused by small, avoidable mistakes that compound over time. Today, I want to walk you through the most common mistakes families make in multi-generational trust planning, and more importantly, how you can avoid them. Let's start with the hard truth. Many trust plans look perfect on paper but fail in real life. Families often assume taxes were handled when the trust was created, but tax law evolves. Without coordination between legal and tax advisors, trust can lose substantial value to preventable inefficiencies. The fix is coordination. Legal and tax professionals should work together. GST allocations should be documented clearly. Property transfers should be reviewed regularly to ensure compliance with California reassessment rules. Tax planning is not optional in long-term trusts. The fourth mistake is relying on one-size-fits-all templates. Online trust forms and generic templates may appear cost-effective, but they rarely address California-specific law or complex family dynamics. Templates often lack flexibility, clarity, and protections needed for real-world administration. Effective trust planning requires customization. Real estate, businesses, out-of-state assets, blended families, and future law changes all require tailored provisions. Flexibility tools like decanting authority and amendment clauses prevent trusts from becoming obsolete. Cheap documents often become expensive problems. The solution is simple but often ignored. Review the trust every 3 to 5 years. Trigger reviews automatically after major life events, and build flexibility into the trust so it can adapt without court involvement. The fifth mistake is ignoring family communication. Even a perfectly drafted trust can fail if beneficiaries don't understand it. Lack of transparency breeds resentment, suspicion, and challenges. Beneficiaries who feel excluded are far more likely to contest trustee decisions. Families can avoid this by holding structured family meetings, providing plain language summaries of the trust, and documenting discussions and expectations. Communication turns a legal document into a shared family framework rather than a source of conflict. Silence creates litigation. Transparency prevents it. The sixth mistake is neglecting trustee oversight and record keeping. Trustees are legally required to act transparently, yet many fail to do so. Missing documentation, incomplete reports, and vague explanations are often the first signs of deeper problems. Annual accounting should be mandatory. Independent audits add another layer of protection. Some trusts benefit from appointing a trust protector, a neutral party who can resolve disputes or replace trustees without court involvement. Oversight protects both beneficiaries and trustees. The seventh mistake is failing to include flexibility for future change. Rigid trusts may protect assets today, but create barriers tomorrow. Without flexibility, trustees may be unable to adapt to new tax laws, economic shifts, or beneficiary needs, including decanting provisions, amendment authority for specific events, and successor trustee plans ensures continuity. Flexibility is not a weakness in trust design, it's a safeguard. The eighth mistake is overlooking special family circumstances. Blended families, second marriages, minor children, or beneficiaries with disabilities require careful planning. Ignoring these realities invites conflict. Clear provisions for step relatives, special needs, trusts for disabled beneficiaries, and defined guardianship and inheritance rules reduce emotional and legal disputes later. Every family is unique. Trusts must reflect that reality. The ninth mistake is poor asset diversification and risk management. Many trusts are overly concentrated in real estate or a single business. That concentration increases risk, especially during market downturns or liquidity crises. Trusts benefit from written investment policies, professional asset management, and regular rebalancing. Long-term stability depends on diversification and disciplined oversight. The final and most damaging mistake is trying to do all of this without professional guidance. Trusts operate under layered legal, tax, and fiduciary rules. One drafting error or administrative misstep can trigger litigation, unnecessary taxes, or probate involvement. Families avoid this by building coordinated advisory teams, clearly defining roles, and committing to ongoing reviews. Professional guidance transforms trust planning from guesswork into governance. Multi-generational trust planning is not about perfection. It's about preparation, communication, and maintenance. Families who treat trust planning as an ongoing responsibility protect not only their wealth, but their relationships and legacy. Avoiding these mistakes today can save generations from conflict tomorrow. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.